Good afternoon. I am Frank Camarotti, and this is my YouTube submission for Full Sail University's Internet in the Law class, IMK672. Our task for Week 4 is to research Priceline.com, terms of use, and ascertain whether it is valid, binding, or if the site is open to lawsuit by users. Additionally, do I have any recommended changes for the site's terms of use? Are Priceline.com visitors informed, and does the website advise these people legally of what the terms of use are within the best practices when selecting Priceline.com? Really, it's up to the audience, visitors or consumers, to strip down what they are agreeing to by clicking or accessing a website. Users must not be in such a hurry to access the information they bypass what lies underneath. Below this shiny veneer, the selected color palette, and the A and B tested focused content, something statistically speaking most never actually see. The terms of user agreement. And it may not be what you assume it is, and the site might not be as attractive after you read it. A couple of clicks will lead you to legal ease, and more importantly, what you are saying yes to. Let us start with the first question. Is the terms of use a valid contract? According to what I've read and researched, I would say yes, it is a valid contract. Thomas Jefferson said, ignorance of the law is no excuse. Fast forward 200 years, and ignorance of the terms of service is no excuse either. Priceline was part of a suit by the New York Attorney General in the late 2000s. Though Priceline settled, Direct Revenue LLC did not and had the case dropped. The court's characterization of the end-user license agreement as a binding agreement offers further support for holding consumers accountable for contracts with companies when consumers opt in on an online agreement. Additionally, in the UK, United Kingdom, court sided with a company called Spada, a site that recommended pool construction companies. The issue was the company chosen was mentioned on the site, but it was not part of the licensed professionals that they vouched for and the consumer selected. The court found the consumer did not seek all the information available, and the site did not breach their duty to inform. In short, assume you are agreeing to will be considered binding. The past 20 years, companies have refined their terms of use and worked them into a correct verbiage to hold users responsible and accountable. The fact you click wrap assent to the terms on Priceline increases the probability a court will side with Priceline. What court weighs is whether 5 areas were covered by the site for the visitors. These mechanisms are conspicuously present the terms of service to the user prior to any payment or in the commitment by the user or installation of software or other changes to the user's machine or browser like cookies or plugins, etc. Allow the user to easily read and navigate all of the terms, be it normal readable typeface with no scroll boxes. Provide an opportunity to print and or save a copy of the terms. Offer the user the option to decline as prominently and by the same method as the option to agree, and ensure the terms of service is easy to locate online after the user agrees. Question 2. Are users bound to it, or should they have to click I agree? On Priceline, by simply assessing the site's information, you are agreeing to the terms of service. This is considered a browse wrap contract. Though once you register, you do a click wrap, where you physically agree to or disagree with the terms of use. Question 3. If you have a dispute with Priceline, can you sue them? Why or why not? Not technically sue them, but you may bring a claim against Priceline in a very restricted way. It's called a mandatory arbitration. Mandatory arbitration is a form of alternative dispute resolution in which 2 or more parties are required to submit their dispute to an arbitrator. Such parties should not opt for litigation. if the contract term that prevents judicial attention from them is disputed. For you must notify them of your dispute, price line that is, within 60 days and allow them to sort out a resolution. If that doesn't work, it goes to the American Arbitration Association, or known as the AAA, and whatever they decide is what you get or do not get. You have given up your right to appeal. So technically, no, you cannot sue Priceline, though you can be arbitrated, as they say, in a mandatory arbitration, which is different from a judicial lawsuit. Question 4, what changes would you recommend? Well, based on several cases in our reading, Talk America and Blockbuster name 2, I would recommend rewording the no notice amending of the agreement. Priceline reserves the right and the sole discretion to amend, modify, or alter this agreement at any time by posting the amendment terms on the site. We recommend that you review these terms and conditions periodically. The amended terms shall be effective for and after the date that they are posted on the site. Additionally, terms may apply when you book services or participate in sweepstakes or other promotions available at Priceline.com. Basically, Priceline is using the same line that all of the other ones do. They are going to update the site as they see fit when they see fit to do it, and it's up to you to find out that it's been updated. Regardless, consumers statistically are lazy, and odds they will not read the terms of service or even the privacy policy are really high. Business rely on the fact that one can only speculate whether our ignorance will bind us like the Dilbert cartoon to servitude to the terms. One thing consumers can start doing is use RSS feeds similar to the EFF or Electronic Frontier Foundation TOS backsite that notifies users of terms of service changes. In short, to be a good online surfer or to use sites, it's up to you to understand what you're agreeing to, not up to the site. Thank you for your time. This concludes my presentation. Happy holidays.